All right, good afternoon, everyone. It's 2 p.m., so we're going to go ahead and get started. This is the state expedited accusations calendar. Are the defendants in courtroom 2? I'll wait.
It doesn't appear that they are. They're coming in now.
They're en route. Good afternoon.
Good afternoon. Good afternoon, Ms. Bridgewater. What is my reset date?
It is going to be May the 2nd.
Thank you.
Easing on down the road with this calendar, huh?
Yes, ma'am. But they say don't carry nothing that might be.
There may be a load. So that's why we finna get rid of it now.
Down. All right, we've got about 18, so we're going to move efficiently today. And I understand that there is no conflict attorney, so
okay,
that will make it interesting. Have other members of the public defender's office on the line? I don't see any. Oh, I see Miss Wills. Are you alone today, Miss Wills?
No, Mr. Bartels will be joining me.
Have you and Mr. Bartels had the opportunity to interview all
he's
your
coming
clients?
on now.
I need a breakout room for 2 clients, Mr. Ballard and Mr. Daniels.
Is it possible to call the jail? I don't know if we're going to be able to do a breakout, Miss Wills.
Okay.
Mr. Bartels, have you interviewed all of your clients?
I have, Your Honor. There are 2 clients that were not able to be interviewed. I think I would ask for a breakout to discuss those, as well as a breakout room for a 3rd. I can put that in the chat.
The problem is I don't believe we're going to have the ability to do a breakout today. Is that correct at courtroom 2?
Ballot is gonna be a reset again.
Okay, but the other ones, do the public defenders need to call the jail, or is a breakout possible today?
Call courtroom 2.
Okay, is there a number they can call?
22392.
Thank you. I knew that a breakout might be difficult at this juncture. Let's go ahead and get started. Let's at least explain everyone's rights. This is the state expedited accusations calendar. I am Judge Melanie Williams. Today is April the 18th of 2023. This calendar is for individuals who've been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney at this proceeding. Participants, this proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch this. When I ask each defendant if you understand your rights, these are the rights to which I am referring. All right, hopefully Mr. Bartels and Ms. Wills can give the jail a call in turn, and we can take whoever is not speaking with either of them. Who do I have at courtroom 2 now?
Position 1.
All right, thank you. Good afternoon. Are you Chad Ace or AC?
Yes, ma'am, Judge.
All right, your case is 23 CR 0022366B. You're charged with driving under the influence of multiple substances and driving while your license was suspended or revoked. Do you understand your rights today?
Yes, ma'am.
Thank you. Mr. Howard, can I have this for the record, please?
24 total. What we got? You got an open CP case, given false name, drugs not in original container, violation of Georgia Controlled Substance Act. It's 22 CP 211195. 2015 suspended license, 2013 DUI suspended license conviction, 2007 DUI conviction, another 2007 DUI conviction, and a 2009 DUI conviction. That's it.
All right, 2009, you said?
Correct.
Okay, thank you. Ms. Lewis, please proceed. Good afternoon.
Good afternoon, Your Honor. This incident occurred on April 17th in the intersection of Nesbitt Ferry and Holcomb Bridge Roads. Officers were dispatched to this location in reference to a possible impaired driver. The caller informed the dispatcher that the defendant nearly struck them while driving and appeared to be passed out at the red light. Officers located the defendant at the McDonald's located at 2950 Holcomb Bridge Road and observed the defendant with his head down, and he appeared passed out. The officer, once he approached, noticed a strong odor of alcohol coming from the defendant. The officer also noticed that the defendant was slurring his speech and had droopy, bloodshot eyes. The defendant stated that he had not drank that night, but did confess, that he smoked a bowl of marijuana earlier in the night. The passenger in that vehicle, however, stated that they took shots of whiskey earlier in the night. The defendant stated that he did not have to participate in any of the field tests because his mother is an attorney. Your Honor, for these reasons, as well as the defendant's history of DUIs, the state will be recommending a $3,500 surety bond. That's $3,000 on count 1, $500 on count 2, no driving without a valid license, no alcohol, drugs, or weapons, and an ADET. Nothing further, Your Honor.
All right. I'm just curious. Did you say a bowl of marijuana, Ms. Lewis?
Yes, Your Honor. It's
That's a measurement which I've not heard before, but okay.
it's a
All right.
contraption, I believe. It's an instrument that they put the marijuana in.
Okay.
I believe. I'm not sure.
Okay, I don't really know. I'm not familiar with such things. I just want to make sure you actually said a bowl.
Yes,
All right, Ms. Wills, please proceed.
Thank you, Your Honor. Mr. AC is 34 years old. He is from Atlanta. He does not have any children. He's a sales associate at Rooms to Go. He also is a caregiver for his mother, who is very ill at this time. In light of that, Your Honor, we would ask for a signature on bond. We understand that that is highly unlikely. And so we would also ask for $2,500 surety bond.
All right. Defendant will receive a $2,500 surety bond, broken down 2,000, count 1, 500, count 2. He's to have no drugs, alcohol, or weapons, and he's not to drive unless he has a valid license issued by the Georgia DDS. Is there anything further at this time? All right, sir. Best of luck to you. That concludes your
Thank you,
hearing
Your Honor.
today. All right, take care. All right, who do we have next?
Position 2, Allen.
All right, thank you.
Second or third row.
All right, good afternoon, Mr. Allen. Your case is 23 CR 002371D. You're charged with reckless conduct with the offense date of April the 16th. Do you understand your rights?
Yes, ma'am.
All right, thank you. Mr. Howard?
Third arrest, 2017 DUI, reduced to reckless conviction.
All right, thank you. Ms. Lewis?
Yes, Your Honor. So this incident occurred on April 17th at 618 Deerfield Point in Milton. The warrant alleges that the defendant discharged a firearm into the ceiling of his apartment. There was a witness there, Yolanda Williams, who was the victim in this case. And because of the stance we take on gun violence, this is the reason why we will be recommending a $15,000 surety bond, no further contact with the victim, to stay away from the address, and to surrender all firearms.
Okay. Is the victim on the line? What was her name again, Ms. Lewis?
Yolanda Williams.
All right, I don't see a Yolanda Williams hearing.
My reading on that, I don't believe she was actually like president. I think she's,
Mr. Bartels, your thing is doing that thing again.
I
Try
think
to
she's
hold
a
still.
neighbor. Yeah, I
Okay.
think she's a neighbor, Your Honor, is my impression.
All right, please proceed with your bond argument, Ms. Bartels. Good afternoon.
Good afternoon, Judge. How are you?
I'm well.
Good. Thank you. I've spoken with Mr. Allen. His history, I'm aware of the one prior DUI arrest. I don't know about the other one, but his criminal history would appear to be minimal. He has ties to the community, Your Honor. He is employed as an IT consultant. He actually works two jobs, although one of them may not be in the picture now, but he's also self-employed. He indicates he was born in Decatur. He's 28 years old and has lived in the metro Atlanta area all of his life. He has extended family with his sister, mother, his brother, their extended families, and aunts and uncles all live in the metro Atlanta area. So he has ties to the community. He's not a flight risk. regardless of what did or did not happen, without the benefit of knowing all the evidence, it's clear that this, whatever happened was nothing intentional. And he is aware that as a condition of bond, he would not be able to have access to any firearms. That's not an issue. In terms of the no contact provision, I don't know if anybody has spoken with Ms. Williams. I was not able to reach it, but it appears she is his neighbor and not somebody who was a target of anything deliberate. And in terms of a stay away, well, of course, this is his home and it's where he lives. So we would just ask for, no further violations of the law, and that he be allowed to continue living in his apartment. Regarding the bond, we would ask the court to consider a signature bond. It appears that he would qualify just based on his minimal history. If that's not possible, we would ask for $1,000 good bond. I think that would be sufficient to guarantee his appearance in court.
All right, thank you. Defendant will receive a $2,500 surety bond. He's to have no further, I guess, violent contact with Ms. Williams. I'm not sure that's necessary, but we'll do that at this time. Additionally, he's to have no drugs, alcohol, or weapons. He needs to surrender the subject weapon as a condition of this bond.
I had advised him of that.
Thank you, Mr. Bartels. All right, is there anything further?
Nothing further from the.
All right.
That weapon.
I'm sorry, sir. The best thing for you to do is to speak to Mr. Bartels. Do you have a specific question about the bond?
I apologize, Your Honor.
Yes, I don't want you to make a mistake and say something, okay?
Ma'am,
Call Mr. Bartels. He'll explain everything further to you, all right?
Thank you, Your Honor.
All right.
I'll call your friend, Mr. Allen.
Thank you.
All right. Take care. Have a good day. All right. Next.
Position 3, Anthony.
All right. We're going in order today. All right. Good afternoon, Mr. Anthony. I'm sorry. Is it Amy? Or we're in position 4? 4 is Anthony. Is it 3 or 4?
Oh, I'm sorry. He's position 4.
All right. Not quite in order then. All right, Mr. Anthony, your case is 23 CR 002370A. You're charged with criminal trespass and damage to property, as well as simple battery family violence with the offense date of April the 17th. Do you understand your rights?
Yes, I thought it's simple battery and simple assault, same thing.
Okay, well, I don't want you to say too much, but let's let your attorney speak on your behalf, okay? All right, so the state will clarify the allegations. Go ahead, Ms. Howard, please give me that history.
8th arrest, 2022 suspended license. I didn't see any violence in this history.
Okay,
That's I
Thank-
overlooked it, but I didn't see it.
okay. When was the last arrest? I'm sorry, what year was that?
It was last year. Suspended.
Last year. Okay, thank you. Ms. Lewis, please proceed.
Yes, Your Honor. So this incident occurred on April 17th at 262 Swanee Avenue Northwest in Atlanta. Officers were dispatched on a domestic dispute call, and upon arrival spoke with the defendant. The defendant stated that he and his live-in girlfriend, who is Celine Williams, that's first name is spelled SELENE, Williams, were in a physical altercation. And then the defendant stated to the officers to just take him to jail. The officers then spoke with Ms. Williams, who stated that the defendant got upset with her for questioning where he was all night. The argument turned physical when the defendant hit her in the right eye and forehead. Defendant also pushed Williams down to the floor. Once outside, the defendant threw a brick at Williams' rear car window, causing damage to the window. Ms. Williams' daughter, who was present, she's 18, also heard the altercation. Her daughter stated that she heard them arguing and heard someone topple to the floor. And when she stepped out of the bedroom, she witnessed the defendant on top of her mother. Your Honor, for these reasons, the state will be recommending a $3,000 surety bond. That'll be $1,000 on count 1, $2,000 on count 2, no further contact with Ms. Williams, and to stay away from 262 Swanee Avenue Northwest. And the charges, just for the record, are criminal trespass and damage to property. And second count is simple battery family violence. Nothing further.
Okay. Thank you. I see Ms. Williams is on the Zoom conference. Ms. Williams, you are not required to make a statement, but if you wish to, this is your opportunity. We will just need you to turn on your camera and unmute your screen and raise your right hand so I can place you under oath. All right, we're going to assume Ms. Williams does not wish to make a statement at this time. Ms. Wills, please proceed.
Thank you, Your Honor. Mr. Anthony is 36 years old. He does not have any children. He's employed by Loader and Linter Delivery Systems as a forklift operator, where he's been working there for approximately the past 6 months. He states that the home where he's staying, the address that was listed, the incident location actually belongs to his mother and is his property. So his one request would be that Ms. Williams vacate the property so that he can resume his residency there. He also owns several dogs, 7 dogs to be exact, who he states Ms. Williams is unable to care for. For those reasons, we would ask that she vacate the premises and that he be allowed to resume residency there. My client states he does not have anywhere else to go or alternative housing. However, Ms. Williams does. For those reasons, we would ask for a signature on bond. And if Your Honor is not inclined, we would ask for $1,000 surety bond.
All right, I understand his request. However, I'm not in the business of deciding or ordering the victim to leave, unfortunately. So at this time, defendant will receive a $3,000 signature bond through pretrial per judge. 1,000 count 1, 2,000 count 2. He's to have no contact with Ms. Williams, and he must stay away from the incident location so long as Ms. Williams resides there. He can return one time with a member of law enforcement to get any items and to ascertain whether or not the victim is continuing to live at the residence. If she has vacated, he can return. Additionally, he's to take the 1-day anger awareness class, and he's to have no drugs, alcohol, or weapons as a condition. Is there anything further?
How much was that?
3,000, 1, and then 2.
Is that pretrial?
Yes, per judge.
Thank you.
All right, who do we have next? Best of luck to you, sir. And who is this before me?
Jordan. Position 12, Jordan.
Thank you. All right, give me a second. All right, good afternoon. Your case is 23 CR 002376J. In this case, you're charged with criminal trespass with the offense date of April the 16th. Do you understand your rights?
Yeah.
You do. All right, thank you. Ms. Bickers, I'm sorry, Mr. Howard, please give me that history.
For Jordan, 27 total. 2023, 2022 probation. 2021 shoplifting conviction. 2019 trespass conviction. On probation for battery and trespass as of February of this year. It's 23 CR 000359J. Also got an ag stalking criminal trespass out of DeKalb County. That's it.
Thank you. Ms. Bickers, staff, please proceed.
Yes, Your Honor, this incident occurred April 16th, 2023 at 4,000 Campbellton Road Southwest. And this is where the victim, Mr. Eric Hayden, called the police informing them that he saw the defendant in his house through his Ring camera on his phone. We spoke to Mr. Hayden today, and he said that he does not know the defendant. And he again stated that he did see him on his Ring camera on his phone, and that the defendant took food out of his refrigerator and then went to sleep in the living room area. For these reasons, Your Honor, the state's recommendation is a $2,000 surety bond, no further contact with Mr. Eric Hayden, and to stay away from that 4,000 Campbellton Road address, as well as no alcohol, drugs, or weapons while out on bond, Your Honor. And just for the record, the state did recommend this case to the DA's office, but we haven't received confirmation on the transfer on it yet. And that's all from the state.
Okay, was it recommended to the DA's office based upon past history, or what was the reason for the recommendation?
For a possible burglary.
Okay, thank you. Mr. Bartels, please proceed.
Yes, Your Honor. I've spoken with Ms. Jordan about this case. Is it possible for us to go into a breakout room?
I was going to suggest that.
Yeah, I think that would be appropriate.
If I could go into a breakout with Ms. Bickerstaff, Ms. Falk, and Mr. Bartels, I would appreciate it.
Okay, Judge.
Thank you. Thank you, Ms. Grace. How are you today?
Good.
All right, I see that Mr. Hayden is present on the Zoom conference. Mr. Hayden, I'm going to give you an opportunity to make a statement if you wish to. If you do, I'd like you to turn on your camera. All right, and I do want to explain, today is not a hearing where, I'm going to sentence the young lady here or any type of assessments for probable cause are being made. This is simply a bond hearing. And as this is a misdemeanor offense, she's entitled to a bond today. All right, I see that Mr. Hayden is present on the Zoom. Okay, I hear an echo of my own voice. Mr. Hayden, do you wish to make a statement? The court will hear from you if you do. If you do, you can raise your right hand. You're not required to make one, though. Okay, do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
I do.
All right, you can put your hand down. And again, I'm familiar with the facts of the case. What would you like to tell me at this time?
The person was in the house, nothing further.
All right, thank you, Mr. Hayden. I appreciate you coming to court and making the statement today. At this time, defendant will receive a $2,000 surety bond. She's to have absolutely no further contact with Mr. Hayden and must stay away from the incident location. Additionally, she's to have no drugs, alcohol, or weapons, and she will be reset to state all purpose on May 2nd. Is there anything further? All right, hearing none. Best of luck to you. Who do we have next?
Position 11, Hollingsworth.
All right. All right, good afternoon, Mr. Hollingsworth. Your case is 23 CR 002377F. In this case, you're charged with battery, family violence, and obstruction with the offense date of April 17th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have that history, please?
Third arrest, 2016 battery DV dismissed. 2017 possession of marijuana. That's it.
Okay, thank you. All right, Ms. Lewis.
Yes, Your Honor. This incident occurred on April 17th at 6975 Roswell Road in Sandy Springs. Officers responded to a domestic dispute call, and it's to note that the dispatchers could hear the victim yelling on the call saying, "Get off of me." The victim in this case is Brittany Bio. The last name is spelled B-A-I-O. Upon arrival, officers met with the victim, who stated that she and the defendant were in an argument that escalated when the defendant got aggressive and got in her face. The victim stated that she put her hand up in an effort to stop him, but the defendant began to throw her around the apartment by grabbing her by the neck and hitting her in the face. Officers observed a busted lip, abrasions on her back, as well as marks on her neck, all consistent with the account of her events. When the officers arrived and spoke with the defendant, they attempted to handcuff him, but he resisted by tensing up his arms and jerking away from the officers. Your Honor, we did speak with the victim this morning. She is extremely afraid of this defendant. She wants nothing to do with him. She describes it as him throwing her around the apartment like a rag doll and slamming her against the wall. She describes it as a strangulation. We also did recommend this go up to the felony division, but we are waiting to hear back from them. Your Honor, for these reasons, the state will be recommending a $6,000 surety bond. That'll be $5,000 on count 1, $1,000 on count 2. No further contact with Ms. Bio. I do apologize if I'm mispronouncing that. To stay away from this address location, and no alcohol, drugs, or weapons. And I would like to sound for her at the appropriate time, Your Honor. Nothing further.
Thank you. Is Ms. Bayo or Bio present? Wishes to make a statement? Okay, hearing and seeing none. Mr. Bartels?
Thank you, Your Honor. I have spoken with Mr. Hollingsworth and reviewed the information that is available. He does dispute that he was the primary aggressor. He did indicate that he was defending himself in this situation. I'm told that he is employed full-time by Roadside Painting. That's a company that paints lines and markers on roads. That is a full-time job. He indicated that his mother and father and siblings and his extended family all live in the metro Atlanta area. He was born and raised here, so he does have ties to the community. I am advised that he does have another place where he could stay. He said if there is a no further contact order, he can stay with his parents. That's at 820 Zion Circle, Zion in Roswell. And it appears that his history is minimal. It looks like there was the one misdemeanor arrest, and then the battery case, which was dismissed. Based on that, we would ask for a signature bond. And if the court is not inclined to grant that, we would ask for a $1,000 bond on the battery and a $500 bond on the misdemeanor obstruction charge. And that's it for now, Your Honor.
Thank you. At this time, defendant will receive a $3,500 surety bond, broken down 3,000, count 1, 500, count 2. He's to have no contact with Ms. Bayo or Ms. Bayo, and he must stay away from the location on Roswell Road. He can return one time with law enforcement to get any items. Additionally, he's to have no drugs, alcohol, or weapons. Is there anything further?
Nothing
Further,
further.
Your Honor.
All right, best of luck to you, sir. That concludes your case at this time.
Am I allowed to say something?
I don't advise that anything you say can and will be used against you. If you have a limited question about the bond, I will hear that, but the best thing for you to do is to give Mr. Bartels a call. Okay?
Okay.
You have a question about the bond, sir?
Yes, sir.
What's the question about the bond?
I understand the sound of this heinous ordeal. However, there's always more sides to stories than whatever.
Yes, there
Sure,
are.
I would-
I don't want you to tell your
I
side today.
understand. I'm not telling my side of the story, but what I'm requesting that if you have in your heart, if you can help me to get out of here. I don't have $3,500.
You don't have to make the full. Mr. Bartels will explain that to you.
I've explained that to. I'll call your mother and explain that to her, Mr. Hollingsworth.
Okay.
Okay, I'll be in touch with your family.
Yes, sir.
Position 13, Kemp.
All right, let's see. All right, good afternoon. Ms. Kemp, your case is 23 CR 002360F, and you're charged with battery family violence with the offense date of December the 3rd of 2020. Do you understand your rights today?
Yes, ma'am.
Your Honor, I'm sorry to interrupt. I just wanted to clarify, Ms. Kemp would be a conflict for our office. So is the court going to be okay with just a pro se bond?
What I'll do is if she does not receive a signature bond, she'll be reset to tomorrow as well. All right?
Thank you, Judge.
In the hopes that conflict attorney will appear. What's going to happen, Ms. Kemp, is the public defender's office is conflicted out of representing and assisting you today, even though you have a right to an attorney. So I'm going to listen closely to your history today. I'm going to listen to the state's recommendation. And if I do not give you a signature bond today, what will happen is you'll be reset to tomorrow in the hopes that a conflict attorney will be present to assist you. Okay? All right. Mr. Howard, can I have the history, please?
6 total. 2016 ag assault. 2013 failure to appear. That's it.
That's it.
Okay.
All right, Ms. Bickerstaff.
Yes, Your Honor, this incident occurred December 3rd, 2020 at 520 Irvin Street, apartment B15. And this is where officers arrive in response to a dispute where the defendant struck Mr. Ricky Walker in the head with an ashtray. The dispute started over a cell phone charger, Your Honor. The defendant and Mr. Walker they lived together at the time of this incident, and Mr. Walker had to go to the hospital due to a laceration on his head. For these reasons, the state's recommendation is a $3,000 surety bond, 1-day anger awareness course, no further contact with Mr. Ricky Walker, and to stay away from the 520 Irvin Street address, apartment B15, as well as no alcohol, drugs, or weapons while out on bond.
Okay, Ms. Kemp, I want you to answer one question for me. That's the and do not say anything else, all right? Do you currently live at 520 Irvin Street?
No, ma'am.
You do not live there any longer. Okay. All right. At this time, defendant will receive $1,000 surety bond. She is to have no contact with Mr. Walker. She is to stay away from the location on Irvin Street and have no alcohol, drugs, or weapons. Should she not make that $1,000 bond, she will be reset to tomorrow's SCA calendar as well, in the hopes that a conflict attorney will appear. All right, Ms. Kemp, that will conclude your hearing at this time. You will be reset tomorrow if you can't make that $1,000 bond, and hopefully an attorney will be present to assist you with this case, okay? All right, best of luck to you. Who do we have next?
Position 7, Cologne.
Okay. All right, sir, your case is 23 CR 0023678. In this case, you're charged with two counts of disorderly conduct and 1 count of obstruction with the offense date of April the 16th. Do you understand your rights?
Yeah.
You do. All right. Mr. Howard, can I have the history?
20 total, 2018 failure to appear, 2013 simple battery DV conviction, 2010 stalking arrest, 2010 harassing phone calls NOLO, and 05 false imprisonment arrest.
All right. Thank you. Ms. Lewis.
Yes, Your Honor. This incident occurred on April 16th at 2808 Lakewood Avenue. Officers were dispatched in reference to a person being irate with Grady. And upon arrival, the officers spoke with the Grady bus 783, and they stated that defendant was being irate and appeared to either be intoxicated or on some type of drug. The defendant was being unruly and did not want to reason with officers, and was also cursing at his child's mother, calling her a bitch. Defendant was also confrontational with Grady, fire, and the police. The defendant attempted to follow the child's mother across the street, asking her to give him the keys to their vehicle, blocking the pathway of other vehicles. And at some point, the defendant sprinted to his vehicle stating, "I've got something for you." At this time, the officers unholstered their firearms. The officers attempted to pull the defendant out of the vehicle and put him in handcuffs, but he resisted. And at this point, officers tased the defendant in the stomach area. Your Honor, for these reasons, the state will be recommending a $1,500 surety bond. That'll be $500 on each count, and no alcohol, drugs, or weapons while out on bond. Nothing further.
All right, Ms. Wells.
Thank you, Your Honor. Mr. Colon is 47 years old. All of the history that was put on the record and stated for the record was fairly old, with his most recent arrest being 2018. He reports that he has 2 children that he takes care of. One is 14, the other is 6, and he is a tow truck driver. He does not make much money, and so we would be requesting a signature bond today. And furthermore, Mr. Colon reports he is diabetic and he's been without his medication. And so he would really like to get home so that he can attend to his health. Thank you, Your Honor.
All right, defendant will receive $1,000 surety bond, broken down as follows. It'll be 500 count 1 and 250 on each of the remaining counts for the total of 1,000. He is additionally to have no alcohol, drugs, or weapons as a condition. Is there anything further?
No, Your Honor.
All right. Best of luck, to you, sir. Who do we have next?
Number 16.
All right. Mr. Turnipseed, your case is 23 CR 0023661J. You're charged with theft by taking and obstruction. You understand your rights?
Yes, ma'am.
All right. Mr. Howard?
This is first.
Oh, all right. That wasn't on my sheet. Thank you. Ms. Bickerstaff, if you please proceed.
Your Honor, so this incident occurred yesterday at about 3 p.m. at 2811 Jonesboro Road. And this is where officers arrived in response to a dispute between the defendant and Ms. Kiara Perry, Kiara Kiara. Ms. Perry told officers that she didn't want the defendant at her house anymore, so she proceeded to drop him off at his home. And when they arrived there, the defendant took the keys out of her hand and shoved them in his pocket and wouldn't give them back to her. And so when officers asked the defendant whether he had the keys, he stated he did have them, but he threw them in the bushes because Ms. Perry was playing with him. And so when officers asked the defendant to produce the keys, the defendant told the officers to take him to jail. And so when officers attempted to handcuff the defendant, he continued to pull his arms away. And so the police had to get him on the ground in order to detain him, Your Honor. And our victim advocate was able to speak to Ms. Perry today, and she stated that they were in a relationship, but they're not in one any longer. And she stated that she does fear the defendant because at the time of the incident, he kept pulling out a gun while it was going on. And furthermore, for these reasons, Your Honor, the state's recommendation is a $4,000 signature bond through pretrial, $2,000 for each count, no alcohol, drugs, or weapons. We're asking that the defendant stay away from Ms. Perry's address of 302 Deering Road, that's spelled Deering, apartment 6207. We're also asking for a one-time escort at Ms. Perry's address so the defendant can retrieve all of his belongings from her residence, Your Honor. That's all from the state.
Okay. I see is it Perry? Ms.
Yes,
Perry
it
is
is.
present on this Zoom conference. If you'd like to make a statement, this is your opportunity to do so. I would just need you to turn on your camera. All right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right. Now, again, as I explained earlier to the last witness, this is not an evidentiary hearing or probable cause. I'm simply setting a bond today. And what I'm most concerned about is whether you wish to have contact with Mr. Turnipseed. What would you like to tell me at this? Oh, I did place you under oath, correct?
Yes,
All right.
ma'am.
All right, just making sure. What would you like to tell me at this time?
I would like no contact. As Miss Bickerson, I guess that's her name. As she stated, I want no contact. I wish for him to come and get the rest of his belongings. And that would be it, ma'am.
All right. All right, Mr. Bartels, I just want to clarify, Ms. Bickerstaff, the charges are theft by taking and obstruction.
Yes, those are the charges, Your Honor. He took her car keys.
Right, I get that part, but
My understanding is they were returned.
yeah, I'm just trying to understand the charges, but okay, we can continue. All right, Mr. Bartels, please proceed.
Well, yes, Your Honor, I have spoken with Mr. Turnipseed. What I have to review is basically a copy of the warrant, and that's it. It's got several paragraphs with the officer's narrative. It says nothing about a gun. So that is, not in the officer's report. It looks like he was arrested at the scene. They searched him because the officer said he was able to recover Ms. Perry's keys in Mr. Turnipseed's right pocket. He didn't say anything about finding a gun on him. So, we find that noteworthy. But regarding Mr. Turnipseed, I'm told that he is employed full-time, that he works for a subcontractor who does custodial work for Fulton County Schools. He does have relatives in the area. Well, he was born and raised in Atlanta, has lived here all of his life. His brother and his mother both live in the area. I am told that Ms. Perry and Mr. Turnipseed do not live together. So there is not an issue with there would not be an issue with a no further contact order or a stay away. And we would agree with the state to ask that he could go back one time with law enforcement to get any belongings if he has anybody there. He has no history. This is his first arrest at age 25. As pretrial had indicated. So we would ask the court to consider a signature bond in this case. If not a signature bond, we would ask for a $1,500 bond, $1,000 on the theft charge and $500 on the obstruction. I think either would be that would be sufficient to guarantee his appearance.
All right, defendant will receive a 4,000 SOB through pretrial, 3,000 count one, 1,000 count two per judge if he was not recommended. He's to have no contact with the alleged victim and stay away from the incident location. He can return one time to the address where the victim resides with law enforcement to get any items. Additionally, he's to have no drugs, alcohol, or weapons. Is there anything further?
Nothing from defense, thank you.
Nothing from the state.
All right. Best of luck to you, sir. What do we have next?
Position 6.
All right. All right, good afternoon. Your case number is 23 CR 002372E. In this case, you're charged with simple battery with the offense date of April the 17th. Do you understand your rights?
Yes, Your Honor.
All right, as this is first arrest, we'll go straight to Ms. Lewis.
Yes, Your Honor. This incident occurred yesterday at 55 Bowen Avenue Southeast. Officers responded to a domestic dispute call and upon arrival spoke with both parties. The officers spoke with Ms. Danielle Murphy, who is the victim in this case. She stated that the defendant showed up unannounced while she was sleeping and then began arguing. The defendant then left and came back 15 minutes later. Murphy stated that the defendant was able to enter her house because he has the password to unlock the deadbolt. Over some time, the defendant left and came back and they would continue to argue. Murphy stated that she told the defendant to leave and he refused. The defendant then shoved Ms. Murphy against her coffee table as she started to push him out of the house. Murphy stated that she called earlier in the week about the defendant coming over unannounced, and the officers were able to check on that, and it corroborated with her story. Officers also observed through the camera at her home that the defendant was refusing to leave her premises. Your Honor, for these reasons, the state will be recommending a $2,000 surety bond, no further contact with Ms. Murphy, and to stay away from the 55 Bowen Avenue Southeast. And I do see Ms. Murphy on the line. I'd like to sound for her at the appropriate time, Your Honor.
All right, Ms. Murphy, if you'd like to make a statement, please unmute and raise your right hand. All right, do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
I do.
All right. Again, this is not I'm not sentencing or handing out any type of conditions today. What I'm most concerned about is whether you wish to have contact with the defendant, but I will hear a brief statement from you. What would you like to tell me, Ms. Murphy?
I would just very much like no contact because he does live fairly nearby, like a mile away. I feel like I can't really get peace in my own house. And just law enforcement escort. He doesn't have anything at my residence, but his car is still parked outside.
I understand. All right. Thank you. I appreciate you coming to court and making that statement. I know it can be difficult, so I do appreciate that. All right, Ms. Wills, please proceed.
Thank you, Your Honor. My client is 26 years old. As it was stated, he does not have a criminal history. He has been or was in a relationship with Ms. Murphy for the past 4.5 years, which is why he did have her passcode information. He is a cloud architect at Capgemini, where he has been employed in that line of work for the past 5 years. He does not reside with the victim. We would not have any objection to Ms. Murphy's request to not have any further contact, but would ask for that one-time police escort for Mr. Chatolavada to be able to pick up his car and any belongings he might have on the property. He does deny the allegations as alleged and has stated that Ms. Murphy has a history of behaving violently and erratically. For all of those reasons, we would request a signature bond at this time, Your Honor.
All right. At this time, I'll accept the state's recommendation. Defendant receive a $2,000 surety bond. He's to have absolutely no contact with the alleged victim and stay away from the incident location. He can return one time with law enforcement to retrieve any items as well as his vehicle. Additionally, he's to have no drugs, alcohol, or weapons as a condition. Is there anything further?
No.
All right.
How much was that?
2,000.
That's good.
Yes, it is.
2,000 good. Okay.
All right, thank you, Mr. Howard. All right, best of luck to you, sir. If there's nothing further, that concludes your hearing at this time.
Thank you.
All right, who do we have next?
Petition 8.
All right,
Is this Daniels, Your Honor? If so, the state has not processed this case for today.
Okay, so Mr. Daniels, your case has been dismissed. The state has dismissed the charges against you.
Was that both charges or I just saw the one?
It should be for both, Ms. Oliver.
They aren't all that simple.
They aren't all that what? I'm sorry, Mr. Bartell.
Not all that simple, Your Honor, unfortunately.
I just saw where it was one charge that,
So the state is dismissing both charges?
Yes, Your Honor. And I will be sure to send down the other if it didn't.
I just showed the criminal trespass and damage to property.
It should be a no pros for both, but we will send it down.
Actually, I'm looking at the no pros right now. Both counts for criminal trespass. If you, Miss Bridgewater, if you look under offense, it says criminal trespass and damage to property, and then a semicolon, and then criminal trespass.
Okay.
So there were two charges that we are.
I know I saw two, but I didn't see the other one. Thank you.
Okay, thank you.
Okay, Mr. Bartels, you were saying something. I believe that if the state is null pros, the charges, that's the end, and those charges no longer holding him in.
Right, yeah, I was just saying, Your Honor, it's too bad not all of these cases are
Oh,
so
okay.
handled so readily.
All right, well, that's it, Mr. Daniels. Once the paperwork's processed, you should, unless you have other holds, these two cases are no longer holding you in the Fulton County Jail, okay?
Good.
All right, have a good day. Take care.
Position 10.
All right, Mr. Grigley, is this who this is?
Yeah, ma'am.
All right, your case is 23 CR 002375C. You're charged with simple battery and theft by taking with the offense date of January the 19th of 2021. Do you understand your rights?
No, ma'am.
All right, Mr. Howard, can I have the history, please?
Grigley, fourth adult arrest. He got an open case in the cab. Theft by taking, hijacking motor vehicle. Ag assault, armed robbery, possession of a firearm during a commission. And he got an Orca bench warrant, 19 CR 005 967C.
You said an Orca bench warrant?
It said dormant, so I don't know. I'll let the state get into that though. All right.
Thank you. All right, Ms. Lewis?
Yes, Your Honor. So this incident occurred on January 19th, 2021 at 1195 Oakland Lane Southwest, apartment A. Officers responded to a fight call and met with the victim, Ms. Christian Franklin. Franklin stated that she was in an altercation with her ex-boyfriend, the defendant. The defendant was upset over a phone call that she was making, and the defendant punched her in the head and face and drug her by the hair to her stairs. Franklin then stated that the defendant grabbed her iPhone and ran out the house with it. Your Honor, for these reasons, the state will be recommending a $4,000 surety bond. That's $3,000 on count 1, $1,000 on count 2. No further contact with Ms. Franklin, to stay away from this location, and no alcohol, drugs, or weapons. And we would like to sound for her if she's on the call at the appropriate time.
All right, is Ms. Franklin present? Wishes to make a statement? Okay, hearing and seeing none, Ms. Wills?
Thank you, Your Honor. Mr. Grigley is 24 years old. He does have pending charges, as it was stated in DeKalb, where he has been incarcerated for the past 2 years. This incident occurred back in January of 2021. So at this point, he's essentially served the maximum amount of time that he could be sentenced to for both of these offenses. In light of that, we would ask for a signature on bond so that Mr. Grigley can just return to DeKalb County and resolve his criminal matters there. He has not been in contact with the alleged victim in this case, and we have no objection to a no contact provision. And that is all I have. Thank you.
Okay. Let me see. We'll look at something before. Okay. All right. At this time, defendant will receive a $2,000 surety bond, $1,000 on each count. He's to have no contact with Ms. Franklin, stay away from the incident location, and have no drugs, alcohol, or weapons as a condition. Is there anything further?
No, Your Honor.
No, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Position 15, Mr. Patterson.
And that is also a conflict case.
Okay.
That's correct, Your Honor, it is.
Thank you. Okay, so Mr. Patterson, there is no conflict attorney present to assist you today. I'm going to listen very closely to your history and the recommendation given by the state. If I do not feel that I can give you a signature bond, I'm going to reset your case to tomorrow's calendar in the hopes that a conflict attorney will appear to assist you. Okay?
Okay, ma'am.
All right. Mr. Howard, can I have a history, please?
Patterson, 11 total. 2020 probation. 2018 failure to appear. 2013 ag assault, possession of a firearm by convicted felon conviction. 2013 probation. He's on probation in Fulton. 13 SC 120471. Criminal attempt to commit burglary. 2014, they gave him 10 years probation. Got ag assault, possession of a firearm by convicted felon. 13 SC 123491. 2015, they gave him 15 years probation. That's it.
Okay. Thank you. Ms. Bickerstaff?
Yes, Your Honor. So this incident occurred yesterday at about 4:10 p.m. at 822 Brookline Street. And this is where officers arrived in response to an argument between the defendant and Ms. Dishay Gates. That's spelled Dishay. And this is where the defendant accused Ms. Gates of being with someone else. So he punched her in the face in front of their children. However, the officers did not know in the police report warrants any injuries that Ms. Gates suffered. So additionally, Your Honor, while Ms. Gates was on the phone with the police, the defendant took her phone. And officers did not recover Ms. Gates' phone from the defendant. For these reasons, the state's recommendation is a $5,000 surety bond, $4,000 for the battery, and $1,000 for the theft. 1-day anger awareness course, no further contact with Ms. Gates or their children. And to stay away from the 822 Brookline Street, and no alcohol, drugs, or weapons while out on bond.
All right. Is Ms. Gates present on the Zoom
Yes.
conference? She is?
No, I'm sorry. I was about to tell her. I don't believe she's present, though.
I don't see Ms. Gates. All right. At this time, defendant will receive a $2,500 surety bond, $2,000 on count 1, $500 on count 2. He's to have no contact with Ms. Gates at this time, and he's to stay away from the incident location. He can return one time with a member of law enforcement to get any items, and he can arrange transport of the children through a third party. I'm going to reset him to tomorrow's SCA in the hopes that a conflict attorney is present. If he makes bond before that time, it will not be necessary. But he is so reset just in case. All right. Is there anything further?
Nothing from the state.
All right. Best of luck to you, sir. I'm resetting your case to tomorrow. But if you make bond before that time, it'll be a moot point. All right.
Thank you, Your Honor.
All right. Take care.
Position 17, Mr. Williams.
All right. Good afternoon, Mr. Williams. Let's see what your case number is. Your case number is 23 CR 0023662A. You're charged with theft by receiving stolen property. You understand your rights?
Yes, ma'am.
All right. Mr. Howard.
First arrest. He gonna need a cosign.
All right. Ms. Bickerstaff.
Yes, Your Honor. So this incident occurred yesterday at 443 Ponce de Leon Avenue. And this is where officers noted in the warrant that another officer spotted 2 juveniles riding around in the area on UTV carts. The officer spotted the carts. At one point, the officer spotted the carts unattended and contacted the carts companies, which are Premier Events and True Event Entertainment. And the companies told the officers that the carts were stolen the night before on 4/16. 2023 at about 11:30 p.m. Later on that day, on yesterday, the officer spotted the juveniles on the carts again and attempted to approach them. The defendant was trying to drive away, but ended up crashing the UTV car and injuring his wrist and breaking his arm. Your Honor, for this reason, the state's recommendation is a $4,000 signature bond through pretrial services with a cosigner. We're asking that the defendant stay away from 1320 Monroe Drive. That is the place where the carts were stolen. We're also asking for an 8 p.m. to 6 a.m. curfew and no further contact with the co-defendant in this case, Mr. Ryan Jones. That's all from the state.
All right, Mr. Bartels, I'm inclined to grant that SOB through pretrial with those conditions. Is there any objection from the defense?
Well, I appreciate that, Judge. I do think a signature bond would be appropriate in this case. Regarding the curfew, the only issue that I would have, he indicates, Mr. Williams indicated to me that he is employed full-time at Gusto restaurant. So if the court is going to have a curfew, we just would ask that there be an exception either for work or school. Other than that, would have no objection to the other conditions.
All right. And what is the name of his co-signer? Do you know?
I spoke with his mother. Ms. Dial, are you here?
I don't believe so.
Yeah, where it says Charlise.
Yes, I'm here. I'm here.
Okay. What is your name, ma'am?
My name is Charlise Dial.
Spell the last name. We see your first name.
It's gonna be D-Y-A-L.
Okay. And you're gonna co-sign for your son?
Yes, ma'am.
All right. Mr. Howard, do you need other information?
You waive?
I'm sorry, I didn't hear you because I'm kind of walking.
Not you, Miss Dial.
You waive
Mr.
it?
Howard, I'll waive it, yeah.
All right. But she need to have valid ID though, to make sure when she
You
go.
need to have valid ID when you pick him up, all right?
Okay, I'm gonna pick up.
Oh, hold on one
question.
second. 1 second.
I have one question.
Okay, the best thing, Mr. Bartels will give you a call, okay?
No, hold on. What's the question? It might be related to that.
I might just want to know, do I pick him up today?
I'll put it in the chat for you, so don't log off.
Okay. Let me
He
do
just
my
wants to know
ruling.
how to get him and co-sign.
Right, let me do the ruling first before I forget what it is. All right.
Yeah, let's go
At this
ahead.
time, because I'm close to forgetting, getting older. At this time, defendant will receive a $4,000 signature bond through pretrial services. His mother is going to serve as the co-signer. Her name is Charlise Dial. He is to have an 8 p.m. to 6 a.m. curfew with the exception of going to school or work. It does not include school events, literal school. Additionally, he is to, of course, have no drugs, alcohol, or weapons and have no contact with the cross defendant last name Jones. All right. Is there any? Oh, and he must stay away from the address on Monroe Drive, as well as whatever. What is the address on Ponce de Leon where they were actually?
That was the area they were driving the UTVs.
What is?
He lives around there, Judge. He lives
house?
right in.
Okay. Well, I won't exclude him from his house. I thought that might have been Ponce City Market. All right. I believe that concludes it all. Miss,
How much was, okay, I got it. No problem.
it was 4,000.
I have it.
I'm still here. Do I need to go?
Did you check the chat, ma'am?
Huh?
Did you check the chat?
Let me look into the chat. Hold on.
Just give me them curfew hours again, please.
8 p.m. to 6 a.m.
Unless working.
Unless working or going to school, not school events, school.
All right.
All right. Does that conclude everything?
I think from the defense.
All right. We don't want to see you back here, sir. Behave. All right. Who do we have next?
Position 1 on the add-on calendar,
Oh, I was unaware there was an add-on. Hold on.
height, width.
Did I get the add-on calendar?
Michael
Hold on.
sent it out.
They just sent it out a few minutes ago.
Oh,
The state gonna get a history because I don't have it.
I'm assuming so. All right, Mr. Heightwit, your case is 23 CR 002397A. You're charged with battery, family violence, and criminal trespass, damage to property. Do you understand your rights?
Yes, I do.
I'm sorry, you do? All right. We'll defer to Ms. Falk for the history, I believe. Ms. Falk, please proceed.
Yes, Your Honor. And of course, my computer is acting up just a bit. So let me just pull that history up for you. Okay, so the defendant has one previous cycle in Georgia that's out of Gwinnett County in July of 2021 for criminal trespass, and out of, let's see, Richmond County, Virginia. He has, I think I'm counting 1, 2, 3, 4, 5, 6, 7, over 8 cycles. History starts in September of 2004. And the only convictions I'm seeing is a 2008 assault on family member, where he received 6 months jail and 6 months suspended. And I believe that he also had a failure to appear March 21st of 2014 in Virginia, as well as a contempt of court. And then that is all in Virginia. He also has a history out of New York with 2 cycles, one for drug offenses, and that was in 2002. And then one for sale on school grounds, and that was for 2002 as well. That resulted in a conviction. That is all of his history.
Yeah, Ms. Falk, please proceed with the rest of your recommendation.
Yes, Your Honor. So this happened April 17th at 125 Avenue Court. Oh, sorry, Avon Court, AVEN, in Milton, Georgia. So what happened was officers had arrived there and had spoken with Miss Samantha Sheard, who stated that she had been the living girlfriend of the defendant for 3 years. She told police that he was upset at his job as an Uber driver, and that Miss Sheard, that the defendant picked up Miss Sheard's 65-inch television inside their bedroom, threw it in the downstairs living area where she was standing. That shattered the television, and that he also threw their bedroom dresser down the stairs, damaging it. She was unsure how the front window was damaged, but there was also damage to that front window. She stated that he then attacked her with his keys, causing a cut to her left cheek. And then she then threw his laptop to the ground, and that's when he threw the television, and the glass shattered and struck her right knee, causing a deep cut. Based on the observations of the damage, the defendant was taken into custody and charged with family violence, battery, and criminal trespass. The state's recommendation is going to be a $4,000 surety bond, $3,000 on the family violence battery, $1,000 on the criminal trespass. We are going to ask for no further contact with Ms. Sheard, as well as no alcohol, drugs, or weapons, and stay away from 125 Avon Court in Milton, Georgia. Unfortunately, due to the timing of when this case came about and we were notified of the case, we did try to reach out to Ms. Sheard, but we're unable to get in contact with her. So that's why we are asking right now for no further contact. Thank you, Your Honor.
All right, Mr. Bartels.
Yes, Your Honor. I have spoken with Mr. Height-Witt regarding his history. There was, I think we heard something about an open case. He indicates that he has no open cases. The case in Gwinnett, he indicated, was dismissed. I tried to verify that, but was not able to in the time that I had today. But again, he indicates to me that he has no open cases. He also indicated that he is self-employed. He's started up a landscape company and has business contracts that he is anxious. He's anxious to address these charges, but also anxious to get out of jail and get started with his business. He wants the court to know that he strongly denies the allegations as outlined in the paperwork. He indicated that he was not the primary aggressor and was not responsible for the property damage. He is asking the court for a signature bond based on all of that. If that's not possible, we would ask for a $1,500 total bond with $1,000 on the battery and $500 on the criminal trespass. He is also asking for a no further violent contact provision, but I, as with the state, don't have any information I can provide to the court on that, aside from that.
All right. Defendant will receive a $2,500 surety bond, $2,000 on the battery, $500 on the trespass. He's to have no contact with alleged victim, and he must stay away from the incident location. He can return one time with law enforcement to get any items. Additionally, he's to have no drugs, alcohol, or weapons as a condition. And as a reminder, he'll be reset to state all purpose on May the 2nd. Is there anything further?
Nothing from defense, Your Honor.
All right, sir. Best of luck to you. All right, who do we have next?
Position 9, Mr. Dobbs.
All right. All right, Mr. Dobbs, your case is 23 CR 00237 You're charged with simple battery with the offense date of February the 16th. Do you understand your rights?
Yes, ma'am.
All right, it's first arrest, so we'll go to Ms. Lewis.
Yes, Your Honor. This incident occurred on February 16, 2023 at the GSU Student Center located at 55 Gilmer Street Southeast. Officers met with the victim, Ayanna Crystal. Her first name is spelled Ayyanna. Last name is Cristal. The victim stated that she and her family were visiting the student center when the defendant approached her making sexual gestures. Crystal stated she was in the sitting area of the building when the defendant approached her and made unwanted contact with her by touching her leg. As he was touching her leg, the defendant was stroking his penis. Crystal stated that the defendant got more aggressive when she told him not to touch her, and he did not comply, which resulted in the victim.
Hold 1 second. 1 second. All right, continue.
Which resulted, in the victim kicking the defendant in the groin area. Your Honor, we understand this is his first arrest, but because of the nature of this crime, the state will be recommending a $5,000 surety bond to stay away from all GSU property, no further contact with the victim, Ayanna Crystal, and no alcohol, drugs, or weapons. And we would like to sound for her at the appropriate time if she's on the line, Your Honor. Nothing further.
Right, I was unprepared for the nature of the facts. I would have directed that the live stream be paused. All right, I'm sounding for Miss Crystal at this time. All right, hearing and seeing none, Miss Wills.
Thank you, Your Honor. Mr. Dobbs is 30 years old. He reports that he is a veteran of our military. He's also currently employed at Standard BioTools as a field application scientist. He has been without his medication now that he's been incarcerated, and he states that he might have a possible defense of a medical or mental health condition that may have caused his behavior on that given day, which will be explored later. Mr. Dobbs would not qualify for our services as this is his first arrest. We would request a signature on bond. Mr. Dobbs does not currently live in Georgia at this time. He lives in New Jersey. He was unaware of this warrant. However, once he learned of the warrant, he immediately traveled here to turn himself in to resolve his warrant. But I say that to state that there is no further potential issues of Mr. Dobbs coming into contact with this victim or being on the GSU campus. So for those reasons, we would request a signature on bond. And if Your Honor is not inclined to do so, we would request a $1,000 surety bond.
All right, defendant or receive a $2,000 surety bond. He's to have no contact with alleged victim and of course, stay away from all Georgia State University campuses. Additionally, as a condition of this bond, he's to have no drugs, alcohol, or weapons. Is there anything further?
Nothing further, Your Honor.
All right. Best of luck to you, sir. That concludes your case. Does that complete the entire calendar? I know that, are there announcements for positions 3, 5, 14, and 18?
Your Honor, if we could go into a chat room or a breakout room for 14 and 18, I could address those.
Have they waived appearance?
We can waive that, Your Honor. I've not been able to, well, number 14 would waive, 18. I have not been able to speak with him, but he's been reset twice already. So I think I know what needs to be done with that case.
Okay, we'll go into a breakout shortly, but is there announcements for positions 3 and 5?
As to 5, it's the same issue as the other case. It's been medically reset twice now. So I will file the necessary paperwork for that. Position 3 is a conflict that was reset from yesterday.
Is position 3 at courtroom 2?
I think,
Oh, ma'am, he's medical reset as well.
Medical
he is
reset?
on loan to Grady.
Yes.
Okay. Okay, nothing we can do about that. All right, courtroom 2 can be excused. Take care. Have a great rest of your afternoon. And if I could be placed to a breakout briefly with members of the state and defense to discuss the remaining cases, we'll rely on the state for whatever history we may need while in that breakout.
Okay, Judge.
Mr. Bartels, if you or anyone else who does not need to hear the calendar reviewed, you are free to go. But that does conclude the state expedited accusations calendar at this time. Those who don't wish to review the calendar are free to go. Otherwise, Ms. Bridgewater, will you please review for me? And I think we
Certainly.
did quite well easing on down that road. It's
We did it. Okay, once again, the reset date for the SAP calendar is going to be May the 2nd. Position number 1 is going on the SAP calendar with a total $2,500 good bond. Position 2, SAP 2,500 good bond. Position 3 is going to be reset till tomorrow. Position 4 is reset further notice with a $3,000 total SOB through pretrial per judge. Position 5, reset till tomorrow. Position 6 is going to the SAP calendar with a $2,000 good bond. Position 7, SAP calendar with a total $1,000 good bond. Position 8, the entire case has been null pros. Position 9 is going to the SAP calendar with a $2,000 good bond. Position 10, SAP calendar with a total $2,000 good bond. Position 11, SAP calendar with a $3,500 total good bond. Position 12 is going to the SAP calendar with a $2,000 good bond. 13 is being reset till tomorrow with a $1,000 good bond. And by the way, it's being reset because it was a conflict case. Position 14 is a medical reset till tomorrow. 15 is being reset till tomorrow with a $2,500 total good bond. It's being reset because it was a conflict. Position 16 is reset further notice with a total $4,000 SOB through pretrial per judge. Position 17 is reset further notice with a $4,000 SOB through pretrial. And position 18 is medically reset till tomorrow. On the add-on calendar, it is reset to the SAP calendar with a total $2,500 good bond. Any questions, concerns, or otherwise?
What was number 3?
Number 3 is reset medically till tomorrow.
Judge, I'm about to send you that waiver in a minute.
All right, thank you. All right, everyone. That's the end. Take care. See some of you tomorrow.
Okay.
Thank you, Judge. See you later.
All right.
All right,
Bye-bye.
bye-bye.